record, this is Wednesday, March 2nd, 2022. And our agenda today is 3 bills. The first one we will be considering voting on. That's Senator Senjam's Senate File 2854. And for the record, we'll let the record show we have quorum. And this is the Senate Judiciary and Public Safety Committee. Senator Senjam, welcome to the committee.
Thank you, Mr. Chair. Mr. Chair, I have Senate File 2854 dealing with the monitoring of controlled substances, if you will, or at least altering substances at roadside stops. And but I have an A1 amendment that I need to have put on the bill.
Thank you, Senator Senjam. This is the author's amendment, A1 amendment. Author wishes to put it in the form. Senator Matthews moves A1 amendment. All those in favor say aye. Aye. Opposed? The amendment is adopted. Senator Senjam.
Thank you. Thank you again, Mr. Chair and members. This bill was before this body last year, and I think put into the bill. It didn't quite make it through the whole process, but it's an important, I think, idea that needs to be carried forward with it. It has to do with the law enforcement on public highways in Minnesota, confronting situations where they have suspect of perhaps some level of drug abuse or use, whatever the case might be, and that might impair driving. And as I guess most of us know by now, that I mean, certainly there's breathalyzers and ability to test alcohol levels, but there's no real technique or tool available to test for the presence, if you will, of any other kind of chemical substance in the body. So this is an oral test process that's been devised, and what this particular bill proposes to do is set forth a pilot program where this particular tool can be tested for accuracy and all of the things related to the kind of situation the officer is confronting. And perhaps if all goes well in the test experience, then in a subsequent bill later on, this can be applied more generally. But it's a one-year pilot study. It has to do with developing initially a plan with the Commissioner of Public Safety involving certainly other appropriate groups and putting a test plan together. Oral fluids would be obtained for this project, certainly by law enforcement officers on the highway system. Any driver, this is a voluntary test, a driver would need to consent to taking this test, but so it is voluntary. The results can't be used for arrest or prosecution anyway, and then there's a report to be returned to the this committee, and I believe this would probably be the committee, maybe other appropriate committees as the case might be, for subsequent assessment and decisions, rather, in terms of going forward on this kind of a implementation process. So with this particular tool, so that's the essence of the bill. It's simply can we go forward with an accurate and legally defensible tool that might help police officers on the public thoroughways of Minnesota make some judgments about the impaired nature of a particular driver. And so I have Mr. Leslie, right?
Mr. Hanson.
Hanson, I'm sorry.
I answered it.
I have a witness, a testifier here for me, and he will describe the bill from his perspective.
Welcome to the committee. Would you identify yourself for the record and then proceed with your testimony?
Thank you, Mr. Chair and members. My name is Mike Hanson, and I have the privilege of serving as the Director for the Office of Traffic Safety at the Department of Public Safety. And the bill, as Senator Senjam described, was before this committee last year, was passed last year, and after input from members of the committee. And as Senator Senjam outlined, it's designed to allow us to test the efficacy and the accuracy and the operational aspects of oral fluid sample testing that can be conducted by law enforcement at roadside to help them evaluate a driver who may be impaired by something other than alcohol. In essence, for those of you who may be familiar with what law enforcement calls a PBT, or a preliminary breath test, that is the device that is currently certified and used by law enforcement across the state as a final way to determine somebody's level of impairment based on alcohol. The PBT simply confirms that the impairment that the officer has observed is from alcohol. And we're asking to test instruments that now are capable of doing the same thing for up to 7 categories of controlled substances or impairing substances. The technology itself has been studied and well-developed, and many other states are implementing similar projects across the country. Wisconsin has recently started to use some of these instruments. Indiana has a very robust program that they are rolling out. Michigan is also very involved in a robust pilot that they've extended in their state, and they're now looking to make that pilot permanent. So what we're going to do is put the test instruments in the hands of our drug recognition evaluators to start with. And as Senator Senjum said, this would be a voluntary participation by drivers who have already been arrested for a controlled substance drug offense. And then the results from the roadside instrument would be compared with the actual evidentiary test that the BCA would already conduct based on the arrest that had taken place. And through that process, we can come up with a set of best practices for law enforcement to use in the field. And we can also establish the efficacy and the accuracy of these instruments as a screening tool only. We are not proposing that these would be used in an evidentiary way. They are simply going to be used in the same way that the PBT is used to determine alcohol as the impairing substance. And then finally, just a couple of recent facts to illustrate the extent of the problem of drug impaired driving on Minnesota roads. I just reviewed a report yesterday from 24 DWI officers that the Office of Traffic Safety supports across the state. Fully 27% of the impaired driving arrests that those officers made in 2021 were for something other than alcohol. Some other recent statistics from the National Highway Traffic Safety Administration. They will routinely do roadside surveys of drivers. And what they found in 24 is among weekend, nighttime drivers, about 1.5% of the drivers that NHTSA had encountered are impaired over 0.08 with alcohol. What's alarming is that 22.5% had impairing substances on board. And to further that, in 2018, the Governor's Highway Safety Association showed that 43.6% of drivers who are killed in a motor vehicle crash that are then tested for chemical impairment, 43.6% of those were drug positive. And beyond that, over half of those positive drivers were positive for 2 or more drugs. And there were also, and then 40.7% of them, in addition to the drug that was on board, also had alcohol on board. So we have a significant polydrug challenge as well. And so the pilot project that we're proposing would allow us to study the problem as it exists on Minnesota roads, to build further that database so we can build the countermeasures to address these serious public safety concerns, and then to certify instruments that law enforcement would be able to use in the future. And with that, Mr. Chair, I'd be happy to answer questions.
Thank you. Is there anyone in the audience who wishes to speak for or against this bill? We'll open it up for discussion.
Mr. Chairman, thank you, and good afternoon, Director Hanson.
Good afternoon, sir.
Nice to see you. What's the technology that would be used in this device? Is it infrared spectrometry like with the PBT, or is there some other technology involved?
Director Hanson.
Thank you, Mr. Chair. Senator Latz, it's a great question. And I don't want to over testify into something that I'm really not qualified in. I'm not familiar with the exact technology that's being used. What I can tell you is that we are planning sometime later in March to bring industry and national experts in the technology in for an actual physical demonstration of the technology. We're either going to do that virtually or hopefully in person if we can swing the logistics so that the technology can actually be demonstrated. As far as exactly how they're analyzing these substances, I'm not sure what the technology is that they use.
Senator Latt.
Follow up. One reason I ask is because I'm kind of looking down the road here. We've got a similar gap with regard to ignition interlock devices, where you've got the ability to test for alcohol when someone's trying to start their car, but we don't have a comparable ability to test for controlled substances. Is the department looking down the road at the potential for using this kind of technology, or is it out there already among the interlock manufacturers?
Director Hanson.
Thank you, Mr. Chair. And Senator Latz, another very good point. And as we see this increase in controlled substance use, those are issues that we do need to confront. The technology for ignition interlock for drugs is under development in industry because they also recognize that this is an emerging concern. It's not mature yet where they're ready to roll it out. But much like with ignition interlock, as it becomes more commonly used and it becomes more present in the system, that industry will step in and fill that void, I'm confident.
And then, thank you. It sounds like there are a few other states that are further along in the evaluation process than Minnesota. In Minnesota, we have not usually simply accepted other states' pilot project results and substituted them for doing it here. Part of it because I think we just have greater confidence in our own agency's ability to, and our legislature's ability to fashion and design the pilot project that'll meet our needs. But has the agency taken a look at whether or not, say in Indiana, or some of the other states that are further along in the process, whether they've had a robust enough or data rich enough projects there that we could piggyback on their evaluations rather than creating and waiting for the results of our own?
I think that, or I'm sorry,
Director Hanson.
Mr. Chair, Senator Latz, I think that you make a valid point in that, there has been rigorous testing of the technology conducted already by a number of other states. However, I think it's important for us, for reasons you stated, that we use our own Minnesota validation process for these. Certainly, I think when we work with the BCA lab in the toxicology section, that we will lean on the other states and see what they learned through their own certification processes. But I think most of us, at least from our perspective, going into an evidentiary hearing, it would be logistically much easier to have the certification come from in-house, so to speak, or within Minnesota, rather than have to bring those outside experts in.
And then, Mr. Chairman, just to thank you, that's very helpful to know. In part, it's because of the need to be able to meet the evidentiary rules in Minnesota courts that having the Minnesota-based pilot project will be helpful to lean on. Back to the ignition interlock, one last thought. Maybe industry may be moving along. I would think they'd move as quickly as they can. I'm sure the basic technology is out there, especially if they're already available for roadside testing for fluids for controlled substances. So maybe the agency can encourage them or try to expedite that process as well. Because not only is ignition interlock a whole lot safer for the public, because we know before interlock, and still, there are a lot of people out there that don't have valid licenses because of alcohol DUI revocations, but are out driving anyway, because they figure the likelihood of getting caught is low enough that they'll take the chance so they can still get to work or still get their kids to school, and so on. And a similar problem, with those who get revoked because of controlled substance related DUIs, but they don't necessarily have the ignition interlock options, especially when you get to even the most serious kinds of events, which are criminal vehicular operation or homicide cases.
Right.
People where you could argue there even greater need to have ignition interlock to protect the public from those drivers than from a first time, high test DWI regular alcohol-related DWI. So, and the flip side of that, of course, is we want people, the policy of the legislature has been, we want people to be on the road driving safely and not on the road driving without a valid license, without insurance. That was part of the whole theory behind the ignition interlock as well. So the sooner we can get that technology available for controlled substances, I think the public will be safer. Individual drivers will have an easier time being able to keep their jobs and take care of their families. And it's better all around. And we already have the infrastructure in place because the alcohol ignition interlock system is already pretty mature at this point in terms of providers and installation, maintenance and monitoring and so on. I encourage the agency to
Director,
push industry on. Thanks.
Director Hanson. any
Mr.
further
Chair
comment?
and Senator Glatz, yes, absolutely. I will reach out to my contacts within the industry and encourage that. And when we bring them up or bring them online for the demonstration, I will ask that they make that a part of their presentation to see just where that technology and its maturation is.
Thank you.
Senator Ingebrigtsen.
Thank you, Mr. Chair. Is this working?
Yep.
I think it is. Thank you. Captain, I'll call you Captain, as last I remembered you when you were captain on the patrol. That's been many years ago. I really appreciate this and I went through the process of those PBTs years ago as a young officer and the testing that went on previous to that. And that science was, of course, recorded by the BCA at that time. And from that point forward, it became evidentiary. And it was a good system. So do you see something like this being the same? Do you see in the future any quantitative measurements? So you know what I'm talking about, somebody that's smoked a joint of marijuana or two, and is there any kind of a science yet that you're seeing or law enforcement's privy to be able to say that this is a high absorbent of marijuana or less? Marijuana we know stays in the system for up to a week. So are you seeing anything, looking at the other states that are involved in any of these testing, roadside testing, where they have anything quantitative in? And I think that's probably the goal, I'm guessing.
Director Hanson.
Mr. Chair, Senator Ingebrigtsen, very good point. The instruments to a certain extent will do that quantitative look at a particular sample. Now that opens up a bit of a discussion on, is there a per se level for any type of a controlled substance that we can uniformly apply to human beings? And when we look at drug impaired driving, it's very difficult to use that per se type of measurement the same way we use alcohol, because alcohol affects most human beings the same way. When we're in that controlled substance arena, controlled substances do affect different individuals in many different ways for a variety of reasons that people a lot smarter than me would have to testify before. So there is some quantitative analysis that is currently completed by the instruments that are being used in the field. And there's one state, I believe, and I can't think of the name, which one it is, that does use these roadside instruments as their evidentiary test, including the quantitative analysis. Again, this is an emerging technology, and it will get better the more that it's used and the more that it's developed.
Thank you, Mr. Chair. And so are there anybody, I guess I didn't look at the packet that closely, are there any folks in for or against this technology or this bill moving forward that you know of? I mean, are there, I would think the MAD would be certainly in favor of something like this. Is there anybody against this at all?
Director
That
Hanson.
you know of, or maybe the senator knows? I don't know.
Director.
Mr. Chair and Senator Ingebrigtsen, I'm not aware of any opposition to this. When we introduced it last year, the Chiefs Association supported it, Sheriff's Association supported it, the DWI Task Force supported it. I've reached out to, those same entities again. I've heard back from the Sheriff's Association and they support the legislation. The DWI Task Force, as is evidenced by the letter of support that they submitted, they do support this. I'm not aware of any active opposition to it, sir.
Good. Just one comment and then I'll finish up.
Senator,
Thank you very much. And it's time, it's about time that we've moved forward to this. And we all know that there's a lot of substance abuse going on. And it isn't just alcohol and it's other drugs. And we've grappled with this idea of coming up with how do we deal with that, and hopefully something will come of this because this is a huge public safety issue. And thank you, Senator, for bringing it forward.
Senator Anderson.
Thank you, Mr. Chair. Senator Sanjamore, to your testifier, you mentioned in the testimony that other states are using this technology, and I'm just wondering what states have been very successful as far as that this is kind of a model after, or are we just kind of in the pilot project here that these other states are just doing pilot projects, or have they actually been doing this for quite some time?
Director Hansen.
Mr. Chair, Senator Anderson, there are some states who have been using the technology for an extended period of time. And as I said, Michigan is in the second stage of their pilot project. And they're, I believe this session, actually trying to roll that in as a permanent one. I believe Arkansas has a very good model that's been referenced in the past. And Indiana also has really gone in. They have some significant challenges with controlled substance offenses there. And my counterpart in Indiana has really, they're rolling out these instruments. They started in a small geographic area and quickly realized they needed to roll it out across the state. So there are some models that we could follow, but we will tweak that to meet both the legislation and then also the rules of evidence in Minnesota, so that when we do bring these instruments on board, or we return to this committee and ask for a permanent approval of it, that we have that data that is solid.
Thank you.
Any other questions before this committee? Members, we plan on dual tracking this particular DPS agency bill with the increase in drug-based DWIs on our roads. At least we suspect we need to start this project, I think, as soon as we can. So that's why we're going to vote on this particular singular bill today. And I'll be asking leadership to put this on a fast track so that we can get it to the floor as soon as we can. But the longer the wait, I think the worse the situation gets. And we'd like to move this. Senator Latz?
I'll move the bill, Mr. Chairman.
Senator Latz moves. Senate File 2854. Hearing no further discussion. Senator Latz moves 2854 as amended.
As amended, be recommended to pass.
Be recommended
Refer
to
the
pass.
floor.
Move to the Senate floor. All those in favor say aye.
Aye.
Opposed? The motion carries. Thank you. Thank you, Senator Sanjay. We'll now move on to the rest of our agenda, starting with Senate File 2889. And members, as instruction, the remaining bills will be laid over for further consideration. But we'll move on to Senate File 2889. And that is Senator Ingebrigtsen's bill. Senator Ingebrigtsen, it seems like it's a law enforcement reunion back.
Hi. It seems that way, which is always good. I've always enjoyed those law enforcement reunions.
Yeah, but you're ruining our efficiency in our Senate Judiciary Committee.
I, of course, have had a lot, was around a lot earlier than this young man sitting next to me here, so. But it's always a pleasure to work with him on different projects over the
Yeah,
years.
well, I think you've preceded just about everybody.
All right, let's move on here, Mr. Chair.
Senator Ingebrigtsen, the floor is yours.
Thank you, members, Mr. Chair. Senate File 2889 is an appropriation for crime prevention. And just real quickly, before I turn it over to Sheriff Fletcher, the bill appropriates $2.4 million in fiscal year 2022 from the general fund of the Commissioner of Public Safety to grant to Ramsey County Sheriff's Office to prevent and combat violent crime. The sheriff must coordinate its efforts with other sheriff's offices and police departments within the 7-county metro area as well as Metro Transit. And we've had those discussions here as well, as you know, and may use these funds to reimburse directly compensate peace officers from other jurisdictions who assist in crime prevention efforts. The rest of the bill, I think, is pretty explanatory. It provides $600,000 in fiscal year 2022 from the general fund to the Commissioner of Public Safety for State Patrol's use of air patrol to assist in these efforts in coordination with the Ramsey County Sheriff. I know there's going to be some issues and some questions about this, but before that, Mr. Chair, if I can turn it over to Sheriff Fletcher, he can explain the bill a lot better than I, and we can move forward.
Well, Mr. Chair.
One moment, Senator Ingebrigtsen, you also have a public safety report to the legislature by 2023, I believe.
I'm sorry, Mr. Chair. I have a what?
Sheriff Fletcher, welcome back to the committee. We sure see you a lot this year.
That's probably not a good thing, Mr. Chair, but thanks for having me. I do want to say that the ability to have flight assets from the Minnesota State Patrol is the best tool that law enforcement currently has to actually arrest offenders. I can't overstate it. I've been out on the street so many times that we have their assets in play and we're successful at apprehending serious offenders, carjackers, shooting, drive-bys, et cetera. And of course, Colonel Langer is here and can talk more about the asset. But we are in the situation now, as you know, that when we chase cars, we're liable for things that might result. And we would far prefer to have the ability to have a state trooper up above watching, picking and choosing our spots as to when we can actually surround that car and bring it to a stop. And I told Matt, Colonel Langer, if we had that asset up 24 hours a day, we could significantly impact crime and drop it. And of course, they can't do that. It's a very expensive asset. They have to train a lot of pilots, but expanding the available hours, and he and I spoke this morning, he's always in favor of expanding those hours and bringing additional assets to our help. And we're meeting here in the next, well, we've been meeting to talk about when we can target resources together. But I just want to thank Senator Ingebrigtsen for his awareness of this issue and hope we can add this to our complement in law enforcement.
Right. We'll open it up for discussion.
Mr. Chair,
Senator Ingebrigtsen.
I think what you were asking about earlier is this bill does require the Commissioner of Public Safety to report to the legislature by February 1st, 2023 on how the appropriations were being spent. So I think that's good to get on the record as well. So.
Is there anyone else in the room wishes to speak for or against this bill? Why don't you come up to the testifying table, sir? Welcome to the committee. Would you identify yourself for the record?
Mr. Chairman, members of the committee, my name is Rich Newmeister. When I take a look at the bill and I take a look on line 110, the words coordination, I think of one thing historically through the eyes of history. The Gang Strike Task Force, which was metro-wide, in which in a bipartisan way and with an investigation, there were issues and lessons learned from that. So when I see $2.4 million going in that way, have we as a state and law enforcement entity to hit crime, have we learned the lessons? So my question is, and I think it's important, that when this money is going to be distributed in those efforts, that there be accountability and transparency, and the agency, which would be the sheriff's office, that there be a very well documentation and record keeping of how that money is spent and how it is used to make sure in the efforts that they want to do, because we don't want to do some of the things that we've done before in the past. Now, if you take a look on the back of the page, it talks about a reporting system. One of the things in all my decades here at the legislature that I've observed at times, the legislature will say, we want a report. And then it's left up to the other parties to come back with a report. But I've seen many times over the years where you will say, this is what we want in the report to see if the money was used or not. So when you look at the $3 million being used here for the helicopter and for a somewhat of a coordinated task force on crime, I think you have to have it beefed up a little bit. Some of the things like how many arrests, such things like that, as an example. You want to direct what you want to see how the money is used. Don't let the other parties decide, because they may not give you what you want, particularly in this area of law enforcement, dealing with people and rights and those kinds of things. So, Mr. Chairman, for the record, that those are my comments. I know this bill will probably be laid over and go into the omnibus crime bill or whatever it may be called this year, but some of that accountability language or whatever, I'm sure can be drafted for where you can direct what you want from the folks who are spending this money. Mr. Chairman, members of the committee, it's a pleasure, as always, particularly someone who likes to get involved in the process that we're beginning to reopen again.
Mr. Newmeister, I had a question. On line 1.17, we give this authority and the appropriation to the Commissioner of Public Safety. They'll be the backup organization that will be accountable for those funds. But I do agree with you that this bill may need more specifics in the report. While you're here, can you tell us what specifics you may want to see in that report?
Well, Mr. Chairman, members of the committee, two things that I thought of for myself, some of the things that we learned from a number of years ago. One is how many arrests? Where's the money being appropriated to? Was there any kind of forfeiture kind of issues or things like that? What involved drugs? What involved violence? And then the other thing is, what was technology used? Because as you know, Mr. Chairman and members of the committee, technology moves real fast in the world of law enforcement. So that would be just a general kind of thing at the beginning. And Mr. Chairman, I'd be more than willing to give you some suggested area points to cover.
Mr. Newmeister, there's just a few of us in the legislature that remembers the Metro Street Gang Task Force and how the administration of it was poorly run. I don't think in that regard there was any singular individual or agency recognized as the one to run that particular strike task force. Number one. Number two, it was later found out that there was some sloppy evidentiary standards that were not established, or at least not recognized in the evidence that they seized. The sale and forfeiture of certain evidence, cars in particular, the records of those sales disappeared, as did the money. And so it really was quite an embarrassment for the metropolitan participants in that when that was discovered. In this regard, at least we have the Commissioner of Public Safety to oversee it. There's a direction or a mission directed at to prevent and combat violent crime in the 7-county metro area with a concentration of efforts in areas that have experienced the largest increase in violent crime. So we at least get a parameter of engagement. However, criminal activity goes far beyond just a map on, or a circle on a map. So in this regard, it is beginning to give us a little bit more structure to the organization. But I agree with you. We're going to lay this bill over and we're going to give some thought to what we expect in the report. I think that's good advice. Thank
Mr.
you.
Chairman, thank you very much.
Yeah.
And members of the committee.
Any other discussion? Senator Bingham.
Thank you, Mr. Chair. And the other thing to note on your comments is that this is going to the Ramsey County Sheriff's Office, which is a municipal government entity in an office in the municipal government, which is heavily audited and watched. So that doesn't concern me all that much. But I will say that I really like this idea. I think when you and I, Mr. Chair, were up at the academy with the troopers, we saw the benefit of how they can utilize air patrol in stop and flee, in apprehension and partnering and collaboration. And I think it is extremely important tool. And I think if anybody watches Sheriff Fletcher work on weekends, like my husband does religiously on live on patrol, you see the coordination, and I think it demonstrates itself. So I do hope that this is included in your final bill, Mr. Chair.
Thank you, Senator Bingham. Any further discussion? I see that Senator,
Quit
Sheriff
demoting, quit
Fletcher
demoting
has
him.
returned. What did you say, Senator Ingram?
Quit demoting him, I said.
I'm not sure if he would interpret it that way. Senator or Sheriff Fletcher.
Sheriff Limmer, yeah, if I could impose on our 30-year friendship, before I leave today, I just,
You're imposing.
yeah, 1 minute or less. Thank you, all of you, for everything you're doing to recognize the law enforcement needs throughout the state of Minnesota. I do want to put one thing in your checklist. I've been at this for 44 years. I've never seen the stress and the wellness issues that are facing law enforcement as great as they are now. Mental health and wellness and traumatic stress. Anything you can do in this session to help us make sure we not only retain officers, but retain them in a healthy way, we would greatly appreciate that. Thank you for the imposition.
Hearing no further discussion, Senate File 2889 will be laid over. Thank you, Senator Ingebrigtsen. And we will now move to Senate File 2953 and Senate File 3029. For members and the public, we'll be having both Senator Matthews and Latz present their respective bills back to back. They're slightly different. They kind of go in the same direction. That way we can make comment on their similarities and differences between the two versions. And then we'll move into testimony after their presentation. And testifiers can then comment on one or both bills. We'll start with Senator Matthews.
Thank you, Mr. Chair, and thank you, committee members. I have Senate File 2953 to remove online court filing fee for accessing documents. Just for some background and history, the judicial branch has long had their own access policy for when and how the public can see court data, such as filings and motions, and the legislature has given authority to the courts to charge costs for copies of these documents. For many years, Minnesota statutes have allowed the courts to charge $8 for uncertified copies of court records. Regardless of size, whether 1 page or 1,000, the cost was the same $8. In the past, this was a question of a person physically going to a courthouse and asking for a copy of these records. However, in the past few years, the judicial branch has started a pilot project to get more documents on the judicial branch website so that the public can access them more easily without a physical visit. And this became especially important during the COVID-19 pandemic, when there was limited or none access to the physical court properties. So during the beginning of this project, the judicial branch waived their $8 fee for uncertified copies, but they're approaching the end of the pilot project, and the system will be permanent and fully functional by the end of 2022. The last piece of the pilot project is to rewrite a code to create a shopping cart to begin charging that $8 per copy fee again. And that's what a lot of us have heard about from constituents and from others. I first heard about this through an independent journalist that has utilized this very heavily and was concerned about the transparency piece that would hinder accessing records. So the judicial branch can charge what the legislature authorizes, and this would be a move to change that to not allow for a fee charged to these records. It will waive that, and there will still be questions about whether it is appropriate to waive this fee for online records only or for all records requested, which is, I believe, what Senator Latz's bill does. So I grabbed the first bill that I found dealing with this issue, the online court records one. I also like Senator Latz's version as well, and would appreciate the committee's consideration of this issue as we clear up and make sure that there's open transparency to these judicial records. Thank you, Mr. Chair.
Thank you. Senator Latz.
Mr. Chairman and Chair Matthews, also thank you for the opportunity to present today on this bill and to share the presentation desk with our civil law chair, who is carrying a very similar bill. We have a lot of consensus on this, and it's motivated, I think, by a number of concerns. One is the public's accessibility to judicial documents, which are otherwise already public. It's just there are significant barriers right now to the public being able to access and see those documents. Prior to the advent of the online system through the courts, members of the public would literally have to drive to or otherwise get themselves to a courthouse, wait at the counter, talk to a staff person at the counter, ask for the documents, and be prepared to pay at the counter as well. And to give you an example of the payment barrier, the state courts are required by statute. They don't have a choice on this. They're required by statute to charge $8 for an uncertified copy of the document at the counter. In contrast, the federal courts charge 25 cents a page. There's a different way to do it for typical short documents. It's a lot cheaper to do it in federal court than it is in the state court. So there's the public access to it, but there's also the aspect of access from the media or the press. They rely a lot, and we rely a lot on their reporting of what's happening in the courts. And you can't really get a full picture of what's happening in the courts if you don't see the underlying documents that are related to a case, whether it's the civil or criminal complaint, which lays out the claims of a plaintiff, or in the case of a criminal case of the state, the crimes that they're alleging a person or an accused committed, whether it's supporting documents, whether motions to dismiss or memoranda of law that are filed and that may be public in most cases, as well as just scheduling documents, which now include a lot of notices of remote hearings by Zoom, which are still public court appearances. It's just that members of the public or the press don't have to physically go to the courthouse and sit in the courtroom. They can log in online. And the third aspect of this is from the practitioner's standpoint. And obviously I've got a personal experience on this one. When the pandemic shut down the courts and when the courts reopened, it changed the way a lot of lawyers practice law, especially those of us who are frequently in court. And my law practice, because I do a fair amount of criminal defense, it was quite often physically in the courthouses. As a part of my practice, I'm a volunteer on a panel that advises people who come to court without their own lawyers on how to approach the case, give them some ideas on what they're facing, on how they might talk to the prosecutor about it, help them understand the pros and the cons and so on. And if I were there at the courthouse, I could get a copy of something from the clerk to help me understand exactly what they're charged with. When we started doing this online, it was not so easy because I could look up the basic sheet that lists the proceedings, but I couldn't look at any of the underlying documents. When the pilot project became more advanced and documents like the criminal complaints became available, I could advise people with a lot more information about what their case was. So now I sit at my desk in my law office and I go into a breakout room with people who wish to speak with the volunteer panel attorney when I'm doing it. And there are about 30 of us in Hennepin County, for example, that are part of this volunteer program. It also exists in other counties. And I can tell them, give me a second. I got the court file number from the clerk. I'm going to pull up your documents and I can tell you exactly what you're facing. And a lot of defendants don't understand exactly what they're looking at. They may not be able to cite the specific nature of the offense that they're charged with. They might not know they've got 3 counts instead of 2 counts that they're facing. I can look all of that up online. I can also get copies of other documents that are available to the court, including telling them, what they're here for. Is there a warrant out for their arrest? Exactly what the story is. So I can do my job better and more easily. Pro se defendants out. There are a lot of other pro se defendants out. There are a lot of other defense lawyers that would be able to access information more easily as well. And this would extend also to civil cases. So I can do the same with other civil cases that I work on because my practice is a mixed practice. And I got feedback from a lot of other defense lawyers in the field about how valuable this tool was for them. And I started reaching out to the Bar Association, for example, and they have a letter in our packet where the Bar Association supports the free access to these documents. So for for public access, for the media access, a very important constitutional role that the media plays to inform the public about what's happening in our criminal or in our justice system, criminal and civil justice system, and for practitioners. As well as, I suppose, the individuals who have cases in court that want to learn more about or get their own documents. There's an advantage here for everyone. And $8 a document is just a big barrier, especially if you're downloading 3-4 documents per case. All of a sudden, you're looking at, just to find out what the basic charges are, and some other, and remote hearing notices and stuff like that, you're already talking $16. $24 every time you need to do that. So this would work out better for all of our civil society, I think, if we have more equitable, indeed, free access to the courts. The bill that I have before you simply eliminates the charge for all document access online and at the counter. And I think we'll have some testimony as to the advantage of eliminating it at the counter as well. Not everyone has easy access online to getting online. And, maybe they have access to their cell phones. A lot of people don't have laptops or desktops at home. They may not have printers at home. So they may have to go to the courthouse. And I think, again, if we can lower the barrier, eliminate the barrier other than travel for those who don't have the online access, to be able to get that stuff, it's a whole lot easier for everyone. These are public systems. The documents are public, it seems to me. They ought to be accessible to the public with the lowest barrier possible. Thank you, Mr. Chairman.
We're going to open it up for discussion now. I had one question to both of you, if I could. Is it true that the monies that would be involved, it comes or it goes into the general fund. It doesn't go into a judiciary branch fund at all.
That's correct. Your Honor.
All right, thank you. Okay, Jeff Shorba is remote. Shorba? There you are.
I am here, Mr. Chair. Thank you. I would have been there in person. Sorry, I got a little late notice about this, but I am happy to participate. And I
Why
just,
don't you introduce yourself and then you can go on with your
sure,
testimony.
sure. My name is Jeff Shorba. I'm the State Court Administrator for the Minnesota Judicial Branch. And I was asked to join you today to give a brief update on what we consider one of the biggest pandemic era accomplishments of our court system, which is the launch of online access to district court case documents. As you've heard from Senator Matthews and Senator Latz, we launched Minnesota Court Records online this year on March 17th. It was launched in 3 phases. The first phase allowed users to access most public district court case documents, but only when searching with a case number. So they had to know the case number in order to find the document. But what we saw very quickly was there was a pent-up demand for this kind of service. The first day we launched it, we had more than 3,700 users download more than 10,000 case documents using the application. We spent the rest of 2021 developing the second phase, which we launched on December 7th. And that added several enhancements, including more robust search functionality, allowed people to find documents a little bit more easier. And what we found is at this point, there's been about 3 million documents downloaded from MCRO, which is Minnesota Court Records Online. Then we moved into phase 3, which will provide a little bit more search functionality. It's our final phase. And we'll also get to the issue of fees. So what the fee process that we were using is to try to mimic what was in the statute. And the statute, as you've heard already, required $8 to get a document. So we decided we would follow the statute. We didn't want to eliminate money from the general fund. So we're developing a fee structure that would allow you to look at the first page of a document for free, as Senator Latz was saying, to sort of find out what the document is all about. And I will let you know that about 2/3 of all court documents are only 1 page long. But if you want the whole document, then you'd have to pay the $8 as set by statute. And I understand the Senator Matthews and Senator Latz's proposal. And to tell you the truth, all we would like to do is to figure out an easiest way to deal with this situation. This is really a legislative decision. If you don't want to charge for documents and tell us not to charge for documents, we're not going to charge for documents. If you tell us not to charge for online, we won't charge for online, although my preference, I think our preference is to have something consistent. So as Senator Latz said, those who can't get online aren't charged something at the courthouse versus somebody who can get online and would get it for free. So the easiest for us would be to say we're not charging for documents, and that would increase the transparency. These are, as they said, public documents. So I'm looking just for guidance from the legislature. We are just trying to follow what you had in statute. There is a provision in the statute where the $8 is charged that says if any other services are required by law for which no fee is provided, such fee as compares favorably with those herein should be provided. So we thought this was a comparable service to getting it at the counter. And that's why we were going to move into phase 3 by the end of the year to charge for these documents. But we are perfectly acceptable to not charging. What I will caution you, there have been some bills discussed where maybe they charge $5 for online and $8 at the counter, or $2 online, or a page thing. That's going to stymie our development. We spent a lot of time developing a system that has really received, I think, rave reviews from the public and the media and attorneys. So I just would ask to have some consistent approach so that we don't have to go back and try to spend more money on development for this. So that's my general overview, Chair, and I'm open to questions if people have any.
Thank you, Mr. Shorba. We're going to go through our testifiers and then we'll open it up for questions. The next individual is Mr. John Kavanaugh from NPR, Senior Counsel, that is. Mr. Kavanaugh. Welcome to the committee. Would you identify yourself for the record and then proceed?
Good afternoon, Chair Limmer, members. I am John Kavanaugh. I'm Senior Counsel with Minnesota Public Radio. Today, I'm appearing in front of you representing the Minnesota Broadcasters Association, the Minnesota Newspaper Association, and NPR as well. Our organizations have submitted a joint letter, and it should be in your packet, but the letter is supporting the elimination of the $8 fee to view or download court documents on the new macro system. Minnesotans should not have to ration their research of court documents based upon their ability to afford access to public information. Our readers, our viewers, our listeners, and you ultimately expect us to be thorough and accurate in our reporting. Attaching fees with no relation to the actual costs that provide these services and which simply go to the general fund only serve as an impediment to our work. Already financially struggling local and regional news outlets would be hardest hit by the proposed fee. These organizations report stories important to their community and are critical to the American democracy. Minnesotans are best served by local and regional media with full access to public information. We appreciate the court's upgrade of the macro system and thank Senator Matthews and Senator Latz for bringing forth these two bills. Just to respect the chair's request, we do actually prefer that the online and the over-the-counter or the in-person documents are treated in the same way and eliminate all those fees.
All right. Thank you, Mr. Kavanaugh.
Thank you.
We'll now move on to, got to get myself organized here. Mr. Eric Weefering from Star Tribune. Mr. Weefering, welcome to the committee.
Thank you, Mr. Chair and committee members. My name is Eric Weefering. I'm an editor at the Star Tribune, where I oversee projects and investigations. As you've heard from others, access to criminal and civil court cases is a core function of what we journalists do every day, multiple times a day, often. Imposing fees for viewing or downloading court documents would have an immediate chilling effect on the ability of reporters and the public at large to follow the workings of Minnesota's judicial system. And the proposed charges would be especially burdensome on smaller news outlets in greater Minnesota that are already facing significant financial challenges. The proposed charges also would have a dramatic impact on the watchdog function that citizens of Minnesota expect from journalists. Last year, the Star Tribune published an investigative project exposing abuses by companies that buy financial settlements from accident victims. The reporter spent 2 years on that project. He examined 1,700 court cases from across Minnesota. Each of those cases typically had 5 or 10 additional documents. He also looked at all the other civil and criminal proceedings involving the folks who sold their settlement payments. In total, he examined more than 20,000 court documents. We invested 2 years in reporting and writing that project. Would we have been able to do so if these proposed charges were in place? It's a question I hope I would never have to answer. Court records are public records, as others have said, and they should be available to all, not just people who can afford, people or institutions that can afford to pay for them. Thank you.
Thank you, Mr. Weaver. We'll now move on to Mr. Joel Carlson. Welcome back to the committee, Mr. Carlson.
Thank you, Mr. Chairman and members. It is indeed a pleasure to be back in front of you once again in room 15. I'm Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I represent the Minnesota Association for Justice. I mostly am here so that Senator Matthews knows that I support several of his bills. In addition to that, we recognize that in addition to the good comments that have been made by the courts and others, all of these court costs and fees that you look at are access to justice issues. And whether it is your filing fee that you cannot pay, or the cost it is to get medical records, or the cost to get your documents from the courthouse, they are all access to justice issues. And we applaud these two legislators for bringing these two bills forward, and we fully support them. Thank you, Mr. Chair. Happy to answer questions.
Thank you, Mr. Carlson, and we'll end with Mr. Ryan Elsey.
I'm online, Your Honor.
You're
Sure.
online. I see. you
Yes,
now. Thank you.
Yes.
why don't you Introduce yourself and then proceed with your testimony.
Thank you, Chair. My name is Ryan Else, E-L-S-E. I'm here on behalf of the Minnesota Association of Criminal Defense Lawyers in favor of Senate File 3029. I echo everything that has been said by the courts and Senator Latz about the professional access to the documents, how important it is in doing our job that we have access to those documents, especially in advising indigent clients and being able to provide our services at a low a cost as possible. But I think the one thing that needs to be understood even more is that the equal access to justice issue. A lot of our clients really are indigent beyond what most of us understand, and $8 is a lot of money. That's a meal to them. And they are often the ones that cannot access the documents online. And so they're at the counter, and it's a good reason why the record should be treated the same either way. That goes across the board for eliminating fines and fees. You've seen me up here many times talking about that. We don't have an equal justice system if a rich person can, access and pay fines and fees a lot easier than a poor person. So I'll cut my remarks short so save your time, but I will be here for questions. Thank you.
Thank you, Mr. Elson. Sorry to mispronounce your name. But we're going to move on to discussion. Any questions, comments by our members? Senator Latz.
Mr. Chairman, I guess I'll proceed from here at the committee table, since that's where I took my seat. I just want to note for the public and for committee members that in our packets, we have additional letters of support from MinCOGI, the Minnesota Council on Government Information, from the Minnesota State Bar Association, which is the organized group of all the lawyers in the state, or representing certain as an organization, and from Minnesota Legal Aid, Ron Elwood on their behalf, in support of these bills as well.
Good notation, Senator Latz. Appreciate that. Didn't seem like there's a lot of discussion, but I had a couple questions to either author. Oftentimes when we open up public records, which is an admirable thing to do, we don't anticipate the full cost. And I'm just wondering, I looked at the fiscal notes, but I'll have to ask someone how they came up with these numbers. And does anyone have any direct analysis? Perhaps our fiscal analyst can help me out. The numbers are quite a bit different. $233,000 in fiscal year 23 compared to $362,000 in the same year. And the bottom line in 2025, it's almost double one cost versus the other. So, Ms. Turner, could you maybe just briefly explain how the numbers are so different? We really didn't talk about in the two separate bills how they are different on the funds.
Okay, Mr. Chairman, members. The way I read the fiscal note is the total amount collected by the courts for document fees was $694,000 in 2019 And then it went down to 586 and 20, 460 and 21, and 330 and 22. So it's been going down. They came up with a number of 262, they meaning the Supreme Court Administrator, in 23 and 395 and 24. That number is reflected, that's a total collection, that's reflected in Senator Latz's bill because he eliminates the fee. And Senator Andrews' bill is 59% of Senator Latz's 395 or $233,000. And they just came up with that. That reflects free downloaded documents, but where if you show up at State Court Administrator's office or District Court Administrator's office, you would pay the $8 in person.
All right. I would imagine that's probably reflective of the time of labor costs. If it was requested at the court, people running to and fro, getting files, pulling them up on records.
Mr. Chairman, members, that simply reflects what the legislature said we're going to charge for fees. Right? That's and like it's been stated, this has nothing to do with court financing. This flows directly into the general fund. So it's just a revenue reduction to the general fund. And courts, like Mr. Shorba said, are really indifferent to the fee because it doesn't affect them. They're just the collector. In fact, it's probably easier if they don't have to collect.
Yeah. It's when you compare these figures, either one to a $50 billion budget, it's the proverbial spit in the ocean. Sarah Latz.
Well, Mr. Chairman, I think maybe I would add the marginal cost of not collecting a fee that's not yet charged yet for an online download of a document should be about zero. The cost of the electricity running through the online system to download the document, even if it's printed out at the end users, it's my printer, my ink, that's or my laser cartridge, where the cost is. So, I mean, I suspect part of the fiscal note, which I have not read carefully, is sort of the lost future revenue if there was not the charge at the counter, which now exists, but which will go away. I suspect, maybe that's part of it, been declining already anyway. But heck, it would probably save the environment, because you wouldn't have people driving to the courthouse and incurring the costs relating to that, let alone their own time. And you would eliminate the labor that's involved in getting the documents and presenting them. I would note this does not affect any charges for certified copies. So if someone wants a certified copy of a document that they would need to submit for some legal purpose, they would still need to go to the counter, ask for the certified copy and pay the $14, which is in statute already.
Okay. Thank you. Senator Ingebrigtsen.
Thank you, Mr. Chair. Just a real quick question for you, the authors. For police reports, do you pay for police reports when you go to the counter? Or is that a local decision? I've been away from it so long. I know we used to charge $1 a fee for an accident report, things like that. Is that still going on?
Mr. Chairman, in most cases, the police reports are not filed with the court as a court document. We would get police reports directly from the prosecutor or often referred over to the police department, the law enforcement agency, and then we do pay the cost that the prosecutor charges us or the agency charges us for those records. There are some cases I've seen online, sometimes police reports are filed with a court document and then I can pull them up, if you will, but in most cases, it's not the situation. We're paying for this, as a lawyer on behalf of a client or the defendants, if they're pro se, they pay for them also to get copies of their own police reports in case.
Okay. Any other discussion?
Mr. Chair. It was mentioned there was going to be some energy savings here. I think this should be coming to my committee if we're talking about saving the environment. This will be my green bill of the year.
I don't think I'm hearing any further discussion except from
Nothing that makes
Senator
any sense.
Ingebrigtsen. So this bill will be laid over as well. There might be a little more discussion. Yeah, both bills will be laid over at this time. There's no further business before this committee. We stand adjourned. Thank you all for coming.